Christ. So you work when what better nice night, right? Good morning, everyone. Looks like we got a spry, nice crowd out here. So let's get started. We'll now call to order Department and Agent Subcommittee. It's Wednesday, February 28th, in the hearing room 2 at 9 a.m. Lisa, please take a roll.
Bricken, Carringer,
Present.
Chisholm, Haston, Littleton, Chairman Kiesling, Chairman Holsclaw.
Present.
Chairman Holsclaw, you have a quorum.
Thank you. We have any personal orders that we'd like to address this morning, committee? I think we're supposed to have some students from ETSU of nursing here. Do we have those? Please stand up and let's recognize you. Got a nice looking group there, and I know the drive's more than 50 minutes. I make it every week, so we appreciate you making the drive and being down here. And with that being said, let's go ahead and get started. And to update everybody on the calendar, item number 5, HB 2774, is rolled 2 weeks. And otherwise than that, we've got the calendar will be in order. So let's take up item number 1, which is HB 2831 by Camper. We have a motion. That's quick on that motion.
Yes, it was, Mr. Chairman. Thank you, and Mr. Chairman and committee. Tennessee is blessed with lakes and rivers that most states don't even have.
Okay, now, before you really get into this, you have an amendment on this, right?
I do, yes, sir.
Does it make the bill?
It does, Mr. Chairman.
So let's, what's your drafting code there?
It is 014341.
And we have a motion and a second, so let's go ahead and get that on the bill.
Yes,
So
sir.
you'll be in proper posture. Those in favor say aye. Opposed? It's now on the bill. Now, let's hear what you got to say.
Thank you, Mr. Chairman. Life on our water is a year-round way of life for almost 10,000, almost 100,000 people here in the state of Tennessee. But at the same time, it being a way of life, we need to be safe about it. And I don't know if members on this committee remember, but the original CDOS was about back in the 1970s, was about 18 horsepower. Today, those CDOS is about 300 horsepower, which is about 17 times it was in the 70s. And our Personal Watercraft Act, by contrast, hasn't changed since it passed in 1996. That's 28 years ago. What this bill does is it provides safety for our waterways. It does one thing, Mr. Chairman. It raises the minimum age to operate a personal watercraft from 12, which is our current law, to 16. And Mr. Chairman, the amendment makes the bill that does that. And then I have two people, witnesses that are here that would like to be heard if the committee so desires.
Okay, well, definitely, you said you have two people?
Yes, sir. I have Mr. David Dickerson, who's the Executive Director for Personal Water Craft Industry Association, who
Mhm.
came in from Maryland. And then I have the Honorable Nancy Carol Miller Herron here. She's a former Tennessee Claims Commissioner and a
Okay,
spouse of Roy Herron.
what we'll do at that request, we'll go to session and we'll hear from them.
Thank you, Mr. Chairman.
We're out of session and we do have Nancy Herron. If you'll please come up. And then Dave, you can come up and sit beside her. And what I would like for you to do is state your name and for the record, and then give us your testimony. And I'm gonna give you 5 minutes.
If I push the right
Push
button.
push that little red button and we'll hear you. Okay, now pull that down towards your mouth so we can hear you.
Can you hear me now?
A little bit more.
Okay.
Just lean up towards the mic.
I think you just push the on.
Yeah, it should turn red. When it's red, it's on.
Okay, I'm with you.
Okay. Thank you. Go ahead.
Mr. Chairman and members of the committee, my name is Nancy Miller Herron. As Representative Camper said, I'm the spouse of Roy Herron. I am so grateful that you're allowing me to speak and appear before you today. Over the 4th of July weekend, our son Ben brought several of his medical school classmates to Kentucky Lake, one of Roy's favorite places in the world. Ben was piloting a pontoon boat with his friends aboard while they took turns on the jet ski with Roy. Roy stopped on the water in Panther Bay so one of Ben's friends could get off the jet ski and another one could get on. While they were stopped, a second jet ski driven by an 11-year-old boy plowed into the back of the jet ski where Roy and Ben's friend Kayla sat as Ben and his other friends looked on in horror. Ben and his classmates sprang into action and put Roy and Kayla in the pontoon boat and raced back to the dock. The med students did all they could to help Roy and their friend Kayla. On the way to the dock, Ben called me screaming, "Mama, call Vanderbilt Hospital and get me a helicopter. It's bad. It's real bad." We didn't know the full extent of their injuries then, but Kayla was seriously hurt and Roy was mortally injured. The amazing medical staff at Henry County Medical Center took care of them until they could be transferred to Vanderbilt. And the wonderful doctors and nurses at Vanderbilt did all they could. But the extent of Roy's brain shear injury was just too much. After a week in the trauma unit, Roy was transferred to palliative care, where he died. Kayla endured multiple surgeries and weeks of hospitalization and rehab. She continues to be treated for her injuries to this day, although she is back in school. After Roy's funeral, my boys asked me, "What are we going to do? Who's going to be held responsible?" I said I didn't know, but I assured them there would be an investigation. I'm a lawyer, so I also knew there could be a civil lawsuit to help cover Kayla's ongoing medical expenses. But there was no insurance on the jet ski, and none is required in Tennessee. My boys and I also knew that neither criminal prosecution nor a civil lawsuit would prevent this kind of senseless tragedy from happening to other people. John, Rick, Ben, and I want to do something to make it less likely that other families will have their hearts broken. Under current law, there is no minimum age for operating a jet ski in Tennessee. Let me say that again. There's no minimum age for operating a jet ski as long as there's someone who's 18 years old or older on the jet ski with you. And they're supposed to be able to take immediate control of the personal watercraft in case of an emergency. Now, obviously, that did not happen, although there was an adult on the jet ski that fateful July day on Panther Bay. Under current law, if the jet ski driver is 12 years old, there doesn't even have to be an adult on board. On behalf of my children, I implore you to do whatever you can to spare other families this grief and pain. You can make the waterways of Tennessee safer by passing Representative Camper's legislation. Thank you.
We really appreciate your testimony and we're very sorry for the loss. Now, also, we have Dave Dixon, and state your name, who you're with, just for the record.
Certainly. My name is David Dickerson, and I'm the Executive Director of the Personal Watercraft Industry Association. Mr. Chairman and members of the committee, I just have some short comments. PWIA was founded in 1987, and part of its reason for being is to support safety. We are advocates for reasonable regulations, strong enforcement of those regulations, as well as mandatory boating safety laws. Part of what we were able to accomplish since then has been the mandatory use of life jackets, the cutoff switches, and education, which we feel like has really made it a much better place to be on the water. Our members include the manufacturers of Sea-Doo, which is BRP, Yamaha, which builds the Wave Runner, and then Kawasaki, which makes the iconic jet ski. So there are about 30,000 PWC registered in Tennessee. It is it's a favored vessel for all all incomes, but it's really a great entry to boating, and we think has a super place in the boating world. Another thing that PWIA does is it recommends that operators be 16 years old. And so there are 16 states that currently have a 16-year-old minimum, and there are 10 more that require operators to have passed a boating safety course. We believe that HB 2831 is worthy of your support as common sense safety legislation. We are very pleased to support this bill, and we are very grateful for the committee for bringing it before them and agreeing to hear it. And I would request that it be voted out with approval. Thank you very much.
Thank you. Okay, members, we have questions before we go back in session. Now, you mentioned your boater safety. Now, in Tennessee, does a 12-year-old have to pass the course to be able to use?
Yes, and the way your law is written, it extends up to the age of 36 at this point. And so next year will be 37, 38, 39 years old as being mandatory that you take a boater safety course, pass it, have a safety card before you come to the helm. Now, I think that under your law, there is some provisions for if you're under supervision of someone over 18 that also has a safety card, then you do not have to have it if you're under direct supervision. But this bill would rectify that and make sure that everybody does have education. It's really, we have been advocates for boating safety education all over the country. And I would imagine that we are involved in supporting this bill that created mandatory safety education here as well.
Okay. And all these craft have to be registered, correct?
Mhm.
Doesn't matter the length. If it's powered, it's registered.
That's right. That's
Okay.
right. And yeah, they are 13 feet long, but that doesn't matter. The length doesn't matter.
Mr. Bricken, you're recognized.
Thank you, Mr. Chairman. A question about insurance. I was surprised to learn that jet skis and all did not require liability insurance or some insurance. Is that normal in all states, or?
There are only 2 states that currently require it, Arkansas and Utah.
Okay. Interesting.
I would say too that we had insurance on our jet ski and it cost less than $100 a year.
What was the amount of that insurance? I mean, what did it?
500,000 was liability insurance, just in case if we were responsible for somebody else getting hurt, we wanted to be sure that.
And as you well know today, $500,000 is nothing.
No, it's not.
By the way, how many children do you have in?
3.
3.
One of them is here.
Mhm.
Rick is here. And then John and Ben.
Okay. I'm going to do something probably unprecedented, but I'd like to just take a moment of silence for you and your family, okay?
Thank you.
Thank you. All right. Thank you all for your testimony. Let's go back in session. You are now recognized, Ms. Camper.
Thank you, Mr. Chairman. Thank you all for your testimony. And if subject to any questions, Mr. Chairman, I appreciate a favorable vote.
Okay. Chairman Carringer.
Thank you, Chairman, and thank you, Leader Camper, for bringing this. I've probably said many times in here, my family, we're Norris Lake lovers. My husband grew up on Norris Lake, big water skier, all the water sports, kneeboard, wakeboard, the whole bit. But every year, and we've never owned a jet ski, and nothing against jet skis. But in fact, my husband and I got rid of our big ski boat when the grandbabies came along, and we're in the pontoon stage of life. And most of you, I think, will know what I'm talking about. So, but even when we had the ski boat and he was slalom skiing and all, the jet skis were everywhere. Kids and not, I mean, 9, 10, 11-year-old kids that families come and hey, nobody likes to have a better time and enjoy our Great Lakes and our mountains and the whole bit. But we've got to be safe, as safe as we can be, just like getting in our vehicles every day. And I love motorcycles. I've driven motorcycles before and all, but just coming into Nashville the other night, a motorcycle, I heard it. I said to my husband, "Where's it at?" I hear it. I know it's coming in between me and another car, right? Coming into Nashville. Sure enough, here it comes. I mean, the motorcycles and the jet skis remind me a lot of each other. The motorcycles are the jet skis on our waterways. We now have more people in Tennessee enjoying our waterways, and it scares me to death. I mean, we've had so many come up on our boat right behind our grandbabies who are tubing out there, or they're,
Yeah.
And I understand, we don't have enough TWRA or agents out there to always be out there catching the bad ones, just like the guy on the motorcycle the Sunday evening. So I have insurance on my pontoon boat and have always, and I do understand that in the years past that, and I didn't know the insurance was that, like we say, 500,000 is not, but we've got to put some regulations on it, and they've got to be able to have the insurance, but I don't know. I mean, this has been an issue for years and years, and I never got to meet you, but I am honored that I got to meet your husband, and his book
Yeah.
keeps me in stitches. I keep it on my nightstand because I just need to pick it up every now and then and get a funny story from him. And all of y'all that are laughing know you've read it. And I mean, he was such a joy. He was a pleasure I'll never forget the first time he came into my office when I was first elected. And when I heard this news, I was just heartbroken. And so I just want to say, nobody loves our lakes, loves to enjoy, and wants other people to enjoy no better than I do. But we have an obligation to try to protect and to make sure that people are doing the right thing. And I am just so sorry. I'm so sorry. This legislation needed to come many years ago, and hopefully that it will save some lives. And I just can't say, I can't say enough about how devastated and how big a issue and a problem this is on our lakes all across Tennessee. So whatever we can do, and hopefully save a life. Thank you.
Thank you, Madam Chair, and thank you for sharing your story with us. I appreciate it.
Since she kind of got into that, I'm gonna go back out of session and have Mike Bell and Tori Gaines come up for a minute?
Yes, sir.
Go back out of session. I know you wasn't expected to do this, but I've
That's
got a couple
okay.
of questions.
Bring 'em on.
And first, I'll say TWR does a great job of monitoring our lakes and that kind of stuff. So we're very appreciative of that. But my question to you, and you can just state your name, whoever wants to answer, is how many deaths do we have on lakes and rivers every year?
Give me just a second, Mr.
Okay.
Chairman. I've got that information in here. At least I've got the statistics for the last 3 years.
Okay.
If that'll be good enough. And so I've got the number of incidences, and I've got them broke down by age groups.
And then what I'd like for you to do, once you get that done, supply that to her so she can use that in her next.
Okay. In the age group of less than 12, this is personal watercraft only. So
Okay.
it's not other boats, but personal watercraft only. In the age group of less than 12, there have been 0 incidents, and that's accidents or deaths involving operators that age. In 12 to 15, and that's 0 over the 3 years. In 12 to 15, there's been 9, 10 incidences during that time. The statistics show that the most dangerous group is probably that 16 to 25-year-old males, risk takers.
Mhm.
But we all remember that age.
Mhm.
And but that's what the statistics show, is that's the most dangerous age group operating personal watercraft.
You got anything to add to that?
No, Mr. Chairman.
Do we have any questions for them? You are recognized.
Thank you, Chairman. To you, Senator Bell. Senator Bell. I did not hear a number or the number of incidents in that age group, 16 to 25.
Okay.
I missed that. Could you give me that
let
number?
me add it up here quickly. So that would be 12,
I didn't know senators could add.
26. I don't have that many fingers. 37, 44. Well, no, there's 8, 60, 62, 72, 79, 82.
82, and
82.
that's 3 years. That's 36 months, correct?
That's right. Yep.
All right. Final question, Chairman.
Go for it.
So, you're not going to have to, I mean, this won't entail an additional increase in staff or enforcement in personnel, will it, Tori, or not? You think?
This really goes back to the incident at issue. We're out there every day. Our folks are working these incidents. And at this point, I mean, I think the number in the fiscal note, we didn't presume it would take more staff to handle this.
Okay. And I apologize. One other thing that
Chairman, you
just
wear
hit
it
me, thank you, sir, is when it comes down to this this amendment, then it will or will not require a safety course to pass a safety course to operate this. I'm still not clear on that, Tori.
So, Mr. Chairman, Tori Grimes, General Counsel of TWRA. Generally, all operators shall have a safety course if they're born after July 1, 1989. So I think you heard previous testimony that age is if they're 36 or below, you have to have this safety course. This really doesn't get into that realm per se. They all have to have it to operate, to legally operate a vessel in Tennessee.
Okay, I'm sorry. I just did not catch that. All right. Thank you, TWRA, and thank you, Chairman.
And just for the record, I mean, alcohol and all that's just like driving a car. Is that correct?
With the legislation you all passed last year, yes, the BUI and DUI are functionally equivalent, and they count toward the repeat offenders. So the fourth and subsequent becomes a felony.
So does the agents carry something to test that?
Oh, yes, sir. Our agents are trained in actually how to do field sobriety, both on land and on the water.
Okay.
We make those cases regularly.
Do we have any other questions? Representative Bricken.
Thank you, Mr. Chairman. Kind of maybe two questions. Is it likely that the number of incidents that you have is underreported?
And there's a dollar amount I'm going to look to our general counsel, and I cannot remember what it is, but it seems like it's $2,000 if my memory tells me that any incident that has a dollar amount of that minimum or above by law is supposed to be reported. Now, whether there is some underreporting out there, that is possible. But by law, any boating accident with that minimum number, and my memory tells me it's $2,000, Mr. Chairman, I may be wrong on that. It may be 5, but I know I think it's 2, that anything that or above by law is supposed to be reported.
Yeah, it just would seem to me that if it's personal property damage done by a jet ski or whatever,
yeah,
that a lot of that is probably personally settled and probably doesn't require an investigation there. I assume if it was an injury involved, that would be totally different. But the other is just an operational question. Of the amendment says that the operator would have to be able to take immediate control of a jet ski. Operationally, is that truly possible or not?
That dates back to, I believe, the Boating Act of 1965, which really establishes the framework. It's actually in other sections of this that code section, Title 69, Chapter 9. We use that language in our rule because that's the general standard. Now, operationally, is that possible? They're a lot faster machines and with a lot more power than they used to be. So I think that gets back to reflexes and those kinds of things.
Yeah, I think it's, I don't think it is operationally possible at that crisis moment.
Sure.
That could change an event. I just don't think that is possible. So anyway,
And just for the record, it is $2,000.
Okay. Thank you, Mr. Chairman. My memory was correct.
Any other questions? Question. We're going back in session. Thank you, gentlemen. We're now back in session, and Chairman Carringer, I know you've been standing there. Hopefully you're not too tired, so go ahead.
No, it's all right. Thank you, Mr. Chairman. I'd be interested to talk to former Senator Bell about the numbers with respect to the zero, because this incident happened within that 3-year time frame he referenced. So I don't know when his numbers were actually calculated to reflect this particular incident, but we'll talk about that.
Yeah, we definitely need to get that ironed out for sure.
Yeah, prayerfully, this bill will move forward. We could work through that before the next committee. And with respect to the question from Chairman Brickens, if you're willing to help us work with some language, I'm open to that, but that's a definition that's been clearly defined by the department. But I'm definitely open to that because I think the importance here is that we're safe and that as much as we can do to help our waterways be more safe is the point we're trying to get to here. So
And
I really appreciate it, Mr.
I
Chairman.
totally agree. And actually, if you look at the number of craft on the water, I'm surprised we don't have more than we do because they're everywhere.
Yeah.
But we don't want one
Right.
incident if we can help it.
Yes, sir.
Representative Carringer.
Thank you, Chairman. And it just came to me, and I'm not for sure who to really ask this question, and it's probably covered, but again, I don't know. We have, and I'm sure most all the lakes in Tennessee, but on Norris, we have a lot of rentals that go out on jet skis, pontoon boats, ski boats, the whole bit. So what is state law or what is required on all the rentals? And I don't know, do we need to go back out of session and ask?
They can check their head, but I think it would be the same requirements as if you owned the boat. But the question is does the rental place verify who's getting it?
And since they said that insurance is not, I mean, insurance is not required on jet skis. So when I mean, the boat docks, I mean, that a lot of the boat docks up there rent them out, but then there's also, separate rentals up there. So I don't know. I mean, I just wonder what is the requirement there if they are.
I reckon the big question there is, and we probably need to research that with everyone, is they still have those same requirements, but does the rental place verify that these people have met those requirements?
Well, Mr. Chairman, I can't prove it, but I would say yes, that they do. I mean, I would think that there would be some level of integrity there for the people that's renting them. And the age is 16 that you were referring to, but I would presume that there's a level of integrity where they are checking.
Do we, Mr. Torch, please come back up, and we will go a quick session and get an answer on that. So we're back out of session, and we've got Tory Grimes, TWRA.
Mr. Chairman, 699226, I think speaks to Representative Carringer's point. So in that section of code, there is an exception. If a person is not a non-resident, there is a course, an abbreviated course that should be provided by the marina or the livery actually renting the vessel. And it's supposed to be it's supposed to be a course that's acceptable to the agency, and our staff does work with that. But that gets to her, Representative Carringer's point. So if you have a non-resident that may not have had the standard course that the rest of the population, there is an abbreviated course that they have to certify that they've had it, and it's the responsibility of the marina or the livery to ensure that that's been delivered to them.
Do you feel personally that happens when somebody rents a?
I personally have not inspected that. I know what the standard is, but obviously, we don't have folks that are in the places every day making sure that that indeed does happen. There is a certification that is required for the renter.
Now you said the non-resident.
Mm-hmm. If they're in the operative section of code is 699226D, without providing the renter an orientation pertinent to the motorboat type being hired, leased, or rented. That's the standard. Now, it must be approved by the agency, which we do. We do work with those liveries on that to the extent they've done what they're supposed to do initially. But it's the basic operation, requires safety equipment, rules of operation of vessels, the meaning of the state's waterway marking system, and any pertinent laws that may be specific to the motorboat type. I think there's a card that they get that stays with the vessel. But again, that is an abbreviated course, and it is not the same thing that a resident born after July 1, 1989 would be required to do.
Thank you. Representative Carringer.
And this is probably getting really, really more, I mean, in the legal things, but you have families that come in from out of state. They rent the vacation homes there for a weekend or for a week, say, vacation. And a lot of them bring their personal water crafts down that are licensed in other states surrounding us. So with that being the case, they are not taking these courses or what is really allowed or what our laws are in Tennessee. So they're coming down for a week of vacation and they're landing their 11-year-olds or whatever on their personal watercrafts coming from other states that don't have the same laws that the state of Tennessee has, where they think, oh, this is legal, this is okay for my 11-year-old to be out on our jet ski in Tennessee's lakes. And I know this is so hard to regulate and all. But even the boat docks that rent the personal watercrafts and all out, and they do these courses and they're renting them to the legal age. But I think in what we're talking about too, insurance covers that for that person. But if their 11-year-old or 12-year-old gets on that jet ski, then I guess the insurance is not there
Sure.
to protect.
Sure.
I guess it's just more statement or asking but
Well, and it's
Yeah.
important to point out that Tennessee is, I think we're in the minority now. We're not a titling state for watercraft. And that's an important point. So there is no lien holding of vessels or any of that. And, and I'm obviously can't speak for the industry, the insurance industry, but TASSER actually issued a really good report in 18 or 19 that attempted to kind of chew on all these issues. And it's a really good read. It's dense, but it's a really good read about all the challenging issues of the regulations of watercraft in Tennessee. And, these type of vessels get into that.
Could you get the members up here a copy of
I'd
that?
be glad to send you the link.
I'd love to read that.
And and Senator back there and all. I've had them in my office and speaking about the titling of boats and jet skis and all, because we title everything else that we own, but we've had discussions back and forth on this issue. So we've had a lot of water talks in my office. Like I said, from being on the lake and being a lake lover, I have, like I say, I don't. I love the water and I want us all to have fun and to be as safe as possible. However, we know there'll always be the bad actors out there. But there's a lot of discussion, I think, that probably needs to happen in the future and sooner than later, because we have so many people moving to the state of Tennessee and loving our natural resources and all that. The more and more we have, we got to try to keep it as safe as we can for everybody, yet still enjoy it and, not become like some of our other states that are so highly, it's got to be regulated, but in as best way that we can without just being no fun allowed, hose claw, as we say.
Any other questions? Appreciate that testimony. We're now back in session, and members in the group and the audience, I apologize for taking so long, but I think we got to get this right and vet it as well as we can. So you are now recognized again.
Thank you,
Ms.
Mr. Chairman.
Camper.
Mr. Chairman, I'm enjoying the conversation, learning more myself. I know that we have a lot of lakes here. I remember, when I was in University of Tennessee, Knoxville, and going up to Sevier County and spending a lot of time in some lakes there. But we just wanted to be safe. We don't want to overregulate, but we do want it to be safe. I would hope that we can get it out of this committee, and I commit to working with members as they move forward. If it's some recommendations for the bill, I'm open to that, always open to work with people to make sure we get it right. And that's my goal here, to make our waterways safe for all of our lake lovers and the visitors that's come here. And we just want to get it right. So thank you, Mr. Chairman, and thank you, committee.
I think we've well vetted it. I see any other questions, comments? Question has been called without objection. We are voting on HB 2831. Those in favor say aye. Opposed? You're moving on.
Thank you, Mr. Chairman and committee. And thank you all for your testimony. I appreciate it.
Which brings us to HB 1661 by Chairman Reagan.
Thank you, Mr. Chairman. I have an amendment on this bill.
Okay, and let's, and what drafting code are you showing on your amendment?
13955.
We might need to back up just a second. Did I have a motion and second on the bill? We have a motion and second, and the amendment makes the bill, I'm assuming?
No, sir, but it adds a substantial change.
Okay, we'll go ahead and adopt it. You said it was 13955, is that correct?
13955. Yes,
Do
sir.
we have a motion and second? We do. So on amendment 13955, those in favor say aye. Opposed? So we put the amendment on the bill and go ahead and address the bill.
Thank you, Mr. Chair. Members, this bill, succinctly stated, is about government of the people, by the people, and for the people. And as arcane as it might sound, it involves libraries. Countless constituents are concerned that public and school libraries nationwide are making pornographic materials available to minors. And yes, I said pornographic. My assistant distributed to your offices earlier today examples that were sent to me by constituents. Currently, there is no real recourse for parents or community members on correcting this situation. The library inventory decisions are made by unelected boards and unelected librarians. A more democratic process is required to determining community standards. And I will mention that Title 39 has obscenity laws in it already. This bill is basically copying from Title 39 to Title 10 so that we don't have criminal actions involved. I did talk to several district attorneys preparing this bill. They assured me that they could prosecute under Title 39 and would have no trouble winning a case. However, they pointed out, correctly so, that the robberies, rapes, murders, and so forth ate all their staff time. So they just don't have the staff or the opportunity to be able to do this, which is why I moved it to Title 10. And I am creating in Title 10 the same stuff that's in Title 39 with one exception. This bill creates a petition process to establish community standards. In Title 39, community standards are assumed by virtue of what it says to be established in a court. But this petition, which we just amended, requires 5% of a judicial district's voters in the last gubernatorial election to be on a petition. And in most districts, that's going to be well over 500 to 1,000 plus people. And this is far more democratic than our current system, which has no democratic input whatsoever. Contrary to some remarks that have been made in the press and otherwise, this bill does not ban books. This bill is about requiring libraries to remove inappropriate pieces from access to minors. Adults who had access to any activities and materials before still have that. This is applicable only to minors. This bill also requires the Secretary of State to publish rules that will create the requirements for a petition and dispute resolution. In a nutshell, this bill sets up a process. Those people who might be dissatisfied with materials that are available to minors in a library must inform the librarian, the library, who in turn informs the library board, that they intend to file a petition 30 days in advance. In that 30-day period, no harm, no foul, no cost, negotiations, discussions, any changes can be made without a problem. If that's not satisfactory, then the group who wishes to file a petition can go out and get the petition with the number specified in here. That petition is then taken to the Commissioner of Elections, who verifies that the people on the list are residents. And once that's verified, the library must take action at that point to ensure that these materials are not available to minors. And again, let me stress, they're not removing them. They're just not making them not available to minors. If there is a dispute at that point, the Secretary of State is instructed in their rules to establish a dispute resolution mechanism, which is in accordance with Title IV, Chapter 5, what's known as the contested case process. In the contested case process, the first step doesn't have to involve lawyers or anybody else. It's a meeting of the parties. And again, it can be at no cost. If they choose to bring lawyers or mediators or arbiters, they can, but it doesn't have to be that way. So the first step again is hopefully a discussion to resolve the dispute. If neither party is satisfied or either party is dissatisfied with that, they can then go to an administrative law judge. The administrative law judge can render a decision. And of course, for those of you that are familiar with administrative law judges know they're not judges in the sense of chancery court or district courts. They're lawyers that are specially trained in administrative law. That administrative law judge, of which we have 17 available through the Secretary of State's office, can render a decision. And again, if either party is dissatisfied, they then have the option of appealing to a chancery court. And then, of course, when you go to the court, lawyers are involved and it's going to cost some money. That said, hopefully this gets resolved before it gets to that point. One of the features in this bill is that for that petition to be filed and verified, there is a cost. That cost is between $1,100 and $1,200. So the petitioners are required to deposit $1,200 with the county election commission, who will put it in escrow. And at the end of the dispute resolution process, that money, if the petitioners are on the losing end of the bargain, they're out the money. If the librarian or libraries are are on the losing end of it, they got to reimburse that and the petitioners get their monies back. There's a lot more detail in here and definitions. I lifted the definitions in here straight out of Title 39 with the one exception of what is community standards. I stand ready to answer questions.
About right, because we're a little over the 5 minutes. We have a couple that has questions. Representative Chisholm, you're recognized.
Thank you, Chairman. To the sponsor, would you say that this bill changes the or resets the function of the Secretary of State?
No, sir. I'm sorry, Mr. Chair.
You are recognized.
No, it does not. Secretary of State is already in charge of libraries. Now, across our state, we have a hodgepodge system, if you will. There's the state library system, which includes a lot of libraries directly under Secretary of State. You also have libraries that are not members of that, but that would be included in this bill. And there's some other libraries. It would actually include school libraries, but there's no mechanism for them. This would be a secondary mechanism. And basically, where there's a library in our state, this would cover it.
Chisholm?
So have there been any conversations with the Secretary of State to make sure that they're in the right lane and we're in the right lane as well?
I'm sorry, I did not quite understand your question.
Have there been any conversations with the Secretary of State?
Very briefly in the beginning research on this, yes. There haven't been a lot since then.
Chisholm?
Well, actually, my question is for legal. Will we be able to go out of
Okay,
session?
what we'll do, we'll go to session and hear from legal. You know the drill.
So my question is, would there be any question about constitutionality with this particular bill?
Matt Mundy from Legal. No, I do not believe there are any constitutional issues with this bill.
No, thank you.
Back in session. And we have Representative Carringer up.
Thank you, Chairman. So we got some information this morning, and one is from John's constituent, which I happen to be very, very, very familiar with this beautiful community, very family-oriented community, where the schools, the parks, the grocery store, the fire hall. I mean, it is the most probably beautiful community, one of the most beautiful communities that I know of. And my son would give everything to be able to live in this community. So I get where John's coming from for this constituent that has found that type books with graphic pictures in these books in this community where children are, that's their life. It's just a big old circle right there of ballpark, the everything. So I will say, coming in here this morning, I mean, I didn't know, I mean, I know there's issues on both sides, but seeing this and knowing that these books are in that community where everything is right there. Please, I mean, it's just like going way back in time, and it's beautiful, and the community centers around it. I do understand, you know, some of the universities have question about it because, but however, it's adults that are at the universities. However, you know, if anybody's been to a UT football game on Saturdays, the campus is all just wide open, and there's families and there's kids running everywhere, and they can go into the libraries. And I understand, you know, there could be adult materials out there or available for students taking the anatomy classes and et cetera. So I was reading the amendment, and at first, I mean, before I was told that immediately someone could file a petition and they could get the signatures, and then all the election commission would have to go through and verify all of the signatures, and then would the other side be able to have time to come back on it, and also spending a lot of the time for our election commission to be doing. This amendment sounds to me like there is that time without getting all the legal fees and involvement to be able to come together and talk, and the opportunity, if it is found in violation, that there's time to work that out. Am I correct about that, reading the amendment?
Chairman Reagan.
Yes, ma'am, you are. That was the purpose of the amendment, was to create a buffer zone in there for any perceived infractions to be corrected.
And from being from Knox County, I know that our Knox County libraries have a special card that will not allow anyone under the age to be able to check, because the cards are different and they won't. But I understand too, there's no way that they could stop a child unless one of the workers would happen to walk by and see a child in there with, and we know kids are kids. I mean, you know, I see both sides, and I guess maybe the one big issue is the universities and all. Is there a way that can carve out the universities, and maybe if, I mean, it's not just books, it's pamphlets, it's et cetera, that could be out on tables and in the libraries and all. So
Chairman Reagan.
Thank you for that comment. Let me point out, though, as I mentioned in the beginning, this is lifted from Title 39, which is a criminal code on obscenity. I did not change anything in that except to move it where there wouldn't, technically, if what happens, if you're the situation you've described there, that particular institution is subject to criminal prosecution. This bill doesn't really change that. So if they're complaining about having that out there and wanting an exemption, I submit to you that the criminal code is already there. Changing my bill wouldn't change that. What I did was take what was in the criminal code and just lift it up in definitions and everything and put it under Title 10. So there's no criminal charges to be made there. Now, this can be settled without going through a DA and district court and so forth. So to your point, though, if a library, and it doesn't matter if it's a university library or whatever, has obscene material out there as is defined in Title 39, and those definitions are lifted straight into this, they're already violating the law. This is kind of a way of saying no harm, no foul, fix it. And if you don't fix it, then the people, like I said, government of the people, by the people, and for the people, not government of the people by librarians. So the idea being that we give the libraries an escape valve to avoid criminal prosecution. If somebody had a real burr under their saddle, they could go get something called a writ of mandamus. And if you want to get the lawyers to explain that, and literally try to get force the DA to carry criminal charges. Now, the DA, of course, has latitude and so forth, but my point is this. The activity you're talking about is already against the law. This bill is taking that potential crime and moving it to Title 10, which is libraries, and doing it without criminal penalties. So in essence, I'm giving the libraries an escape valve, if you will, and I'm also involving the people. If somebody has got real serious objections and they go out and get 2,000 signatures on a petition, they've got a pretty sizable group of people that's community standards. And regardless of what the library is, whether it's a university or county library or whatever, regardless of how that librarian feels about that, that's community standards. And that's what the code says. So this is merely a way of telling the librarians that your community that you serve is objecting to what you're making available to minors. And we want you to take action to fix it. Now, the final steps that you've got to go through, like I said, I purposely made this thing somewhat involved so that we can have opportunities for everybody to come to an agreement if it's possible.
We're going to hear from Chairman Haston. He's been pretty quiet, so it's your turn.
Thank you, Mr. Chairman. Chairman Reagan, quick question. Just wanted to try to see how this fit with our Age Appropriate Materials Act that passed in 2022, where we have our public schools have a policy now in place dealing with obscene materials in libraries. And if this did pass, would those schools need to update their policies to incorporate this language in order to be in compliance? Because it would fall underneath, I think, its jurisdiction.
Chairman Reagan.
The straightforward answer to your question based on my research is no. This runs in parallel. It doesn't override or overwrite.
Thank you.
Chairman Littleton.
Thank you, Mr. Chairman. And Mr. Chairman, I didn't get this material this morning till I got in late, and I didn't see it till we were here. But some of this is straight up child porn. So,
Yes, ma'am,
I
you are
mean,
correct.
So that is in our libraries right now?
Chairman Reagan.
Yes,
Legally-
ma'am.
Legally.
What was given to you were screenshots taken by my constituents going around to several different libraries using the iPhone and taking the screenshots. Now and those were from children's sections. And in fact, if you look at the material which is next door to you, you'll see graphic novels, which typically speaking, adults read real novels, not graphic novels, obviously aimed at children. And some of those are actually children's books. I've got a picture included in there that one of my constituents took of a bookshelf, which was on the bottom shelf of a book that's obviously inappropriate for a person under the age of 18 to look at. I would personally think anybody else too, but definitely constitutes that. Members, I did have that package delivered to all your offices this morning. If you need another copy, I'll be glad to provide it.
Chairman Bricken.
Thank you, Mr. Chairman, and thank you for the sponsor. This is I'm gonna call it kind of a complicated piece of legislation you're proposing to remedy what common sense would like to tell me that libraries and librarians would have a mechanism to have obscene pornographic materials somehow isolated within the library and only available for adults. But the operationally, to require a petition by judicial districts, and there's, I understand, 30 judicial districts in the state. I mean, it seems like a very complicated process for the public to have to go through to accomplish this. Again, I mean, in those judicial districts overlap, many overlap multiple counties. So operationally, I mean, if this should pass, I just don't think it's ever going to be executed. So is it likely? You can try to answer that if you would, and then I'll have another follow-up.
Chairman
question.
Reagan.
A straightforward answer to your question is there's already a petition in my district with over 2,000 signatures on it. So yes, it's operationally doable. Furthermore, a judicial district may be a single county or it may be multiple counties. The signatures don't have to come from all over the district. It's a number that's based on the number of voters in the last gubernatorial election. So the idea being that that number could come from the entire district or just a major portion of it. But when you get that number, you've got a valid petition, assuming all the names are adult residents.
I understand. I mean, it just seems like I'm shocked that you've already got that many signatures in your district, but it just seems like a complicated piece of legislation. Assuming the petition is filed, does the operation within every library within the district, schools, public, private libraries within the district would come under it? Is that correct?
Yes, sir.
Does that last forever? Does it have any statutes or limitations of ever to drop off or not?
Chairman Reagan.
The bill specifies that the petition, if it's declared valid, and after all the disputed adjudication completes itself, is in effect, period. Because remember, I lifted a criminal code section. The criminal code would be applicable anyway. I'm trying to get this out of criminal courts and into one that is less fraught with penalties and so forth, but also more accessible to the public. That is the people who pay the taxes to support those libraries. Right now, and even in the university system, the decisions are made by librarians and library boards, neither of which are elected. And if you're interested, I just happen to have the section of code about library boards. There's a CTES 463.
You can provide that to us and
Okay.
for the sake
More
of
than
time.
glad to. But the point I'm making is neither librarians nor library boards are elected. The library boards are appointed and they in turn hire librarians. So it's two steps removed from anybody that's in the public. Now, most cases, county commissions or city councils will appoint the library board. But the library board does not stand in front of the public for reelection and explain their decisions on community standards or violations of it.
I'm fine.
Representative Chisholm.
Thank you, Chairman. So I'm looking at Title 10-1-105, and it says the Secretary of State acting through the Division of Public Libraries and Archives shall be responsible for the proper administration of this chapel and shall establish policies to govern the administration of the state library system. So it sounds like we already have a mechanism to monitor the books that are in our libraries.
Chairman Reagan.
For that particular system, as I stated when I opened my comments, not every library in the state is a member of that system. In fact, it's, if you'll forgive the term, a bit of a hodgepodge.
What percentage would you say?
I would be guessing, sir. I'm guessing it's over a majority, but there's a large number. Again, when you consider that in this library system, this bill covers those libraries as well as all public libraries that are not part of it. I cast a wide net on purpose because, again, the taxpayers are the ones supporting these libraries. And in my mind, the taxpayer should have a direct say. And this bill gives them that.
Chairman Lillard. While you're playing on your phone.
Thank you, Mr. Chairman. I just have some more questions about the child porn being in our libraries.
Yes, ma'am.
I mean, how is that happening?
Well, I can give you some anecdotal research. Now, I'm a trained statistician, so I'm going to be cautious about giving you numbers. But the anecdotal research is that the librarians make the decisions. In many cases, book publishers will send sample copies to libraries. The librarians will make orders. The publishers will include extra books to the library. The librarians will get those and they'll look at them. put a number on it and put it on a shelf. That is the way some of them get there. And frankly, in other cases, they're actually asked for. There is an argument that was made about free speech, and this bill is not intended to infringe on anybody's free speech, except that I will point out that minors in our state have a lot of restrictions and protections on them. Under the age of 17, you're not allowed to enlist in the military without parental consent. You can't get married without parental consent. You can't drive. You can't buy alcohol. You're required by truancy laws to go to school. So minors in our state have a special category, and this bill is about protecting those minors, not adults.
Thank you.
Chairman Haston.
Thank you, Mr. Chairman. Mr. Chairman, I'm for your bill, but I just want to make sure before it gets out of sub, or if it gets out of sub, that we have some clarity on this how it relates to school policy. And I wouldn't mind maybe getting this from legal if we can get this. But you stated earlier that it wouldn't override school policy, but I think that it might actually override school policy. If it does, I just want to make sure that our schools know that their policy would need to reflect that or understand that before it got out of sub. So I wanted to make sure we had that clarity before we moved on.
Without objection, we're going to go out of session. Hear from legal.
If I understand.
Matt Mundy.
Matt Mundy from Legal. If I understand your question, Representative Haston, you're asking if under existing law, if a school makes a decision as to the appropriateness of a book, and then a petition is filed under this bill saying that that book needs to be put in a certain area where it's inaccessible to minors, would this petition trump that school's policy? And I think the answer to that is yes, that it would. More or less because this is the more contemporaneous act that the legislature's passed. There's a presumption that we know what the law is, and I think a court would say that the General Assembly intended for this to supersede that school's policy.
All right, thank you.
Other questions for legal? Representative Chisholm.
So there's a case about constitutionality in Texas. That's I don't remember the number or whatnot, but it has something to do with removing some books, and I think it stepped on the toes of the Secretary of State. So can you speak to that?
Matt Money from Legal. A couple of things. I'm not familiar with that case, but I'm happy to take a look at it if you want to provide me a copy with it. I will say that if it's dealing with the removal of books, that it's probably an opposite to this case because we're not removing books from libraries. We're just restricting access to minors. And I'd also say that if it's a state, Texas state court decision, it wouldn't be binding on Tennessee.
Other question? All right, we'll go back in session. And Representative Chisholm.
Thank you, Chairman. Well, just one final question. So, I would like to be able to connect to some of our local library boards. So, and this is a complex piece of legislation. So, my question is, would you be willing to roll this bill for a week so we can have further discussion on it?
Chairman Reagan.
I appreciate your comment, but I've already rolled this bill a week to put the amendment that you heard on it based on conversations that have been here earlier, not necessarily with this committee, but with committee members. And I don't think that there would be any need to discuss it now. If complexity of the legislation, I'm willing to talk to you privately on that and resolve any questions you may have. But I would remind you, sir, that we only have about 7 or 8 weeks of session left. So to get this bill out of this subcommittee through the other committees it's got to go through and to the floor, a roll is going to be a potential detriment. And I would ask you to talk to me privately.
What we're going to do, Chisholm, you're next. So keep that up, and then we're going to move on down the line to Carringer and try to wrap this up.
Thank you, Chairman. And like I say, we have gotten some more information, and I've got some big questions on what we've seen, and so I am in favor of moving your bill on to full, and hopefully that we could arrange some time with several of us to to talk about this and see what, with the questions that have been asked, to see what we might be able to do to tighten it up, or to be able to answer some of the university questions, and just exactly what is going. And so I'm for moving it on and hopefully having some discussion again before we have full next week.
We appreciate those comments, Chairman. Chairman Reagan.
Thank you, sir. And I'm more than happy to meet with any of you individually or as a group as you choose. An answer that I gave to Chairman Haston earlier about running in parallel, I think there was a little bit of confusion on my part about your question, because technically age-appropriate material in the school library is going to remove pornographic material anyway. So it shouldn't be there. This petition, while it does encompass schools, if that age-appropriate material standard is already there, there shouldn't be anything to file a petition over. So I hope that adds clarity. Thank you, sir. I ask for your support, ladies and gentlemen.
I think we beat this pretty good. So call for question. So we are voting on HB 1661. Those in favor say aye. Opposed? You're moving on.
Thank you, Mr. Chairman and committee.
And the much awaited Representative Powell, we're on HB 1959. We have a motion. Have a second.
Thank you, Mr. Chairman. We had the team director in here earlier today. The committee, I don't know, I think he had to step out. But did want to point out that it is Severe Weather Awareness Week. So something we take very seriously around here is severe weather. We passed a piece of legislation originally called the Safer Places Act. It was amended this last General Assembly. And what it did was make sure that people had a place to go when they face severe weather, so that they can take cover and shelter. And so there are some groups out there. One of the issues we've had is people don't have a way to recognize what a safer place is by an emblem or a logo. So I've been in discussions with TEMA about creating, having them work with some different groups that have already looked at creating these safer places logos, so that TEMA can bless that process, work through the design process with them, be no cost to the state, and be able to have an official Safer Places logo, so that when we do face these severe weather events, people can recognize and know what place they need to take shelter. So with that, I'm open to any questions.
So was this your idea?
I was reached out by constituents who were contacting me and said, how do you actually identify where a safer place is? Which kind of led to the investigation of, that's something that we need to clean up, so that, people have an identifiable way to identify a safer place. I've been in touch with, a director has joined us now, so want to thank him for his work in making sure we keep Tennesseans safe, especially during the Severe Weather Awareness Week. But been in discussion with him about this legislation, and so that's where it comes from.
Chairman Carringer.
And I could be confused, but are we talking about House Bill 1959?
That's what I thought we was talking about.
It says charitable institutions. I don't see anything about safe or whatever. Are we?
So that's what we'd have to do. We'd have to make it in code, so that then charitable institution that open themselves up, which is what a safer place is, a charitable institution. So we have to change that section of code to allow safer places to be, the logo to be adopted.
Unless we're all reading something different, I don't know.
Did we have somebody else want to ask a question? While we're in discussion, Chairman Bricken, would you like to go ahead and ask your question?
Yeah, thank you, Mr. Chairman. I guess it was a few years ago when we modified the handicap I'm not sure, call it logo or emblem. And of course, that was presented and to us as the bill progressed. It just seems to me, I'm reluctant to vote on something without seeing an emblem or the logo. And it just seems like if this has merit, we would have, something that we could approve, like an air raid shelter or something emblem back in the good old days. But maybe those weren't the good old days. I don't know. But anyway, I just would like to see what we're proposing before we pass a law to authorize it.
Joe Powell.
So this doesn't authorize the logo at all. It just allows TEMA would have the abilities to approve that logo. It in no way would authorize or approve any type of logo. It would go through them. They'd be able to promulgate rules around it, and that's simply what it does.
But I think it would be incumbent for them to propose something, then have it as a part of this legislation, kind of the cart before the horse, so to speak.
So there are different organizations who have already created a logo that are out there. They don't have to use this, but if those organizations wanted to present their logo for consideration to save the state money, they could simply use that. That's all that we're trying to do with this legislation.
Okay.
Representative Carringer.
Well, apparently a lot of us have some kind of questions and on this. So, I mean, we can either go out of session and have Matt explain it and so that it's on record and that we, yeah, thank you. Thank you, Chairman.
We're going to go out of session here from legal.
Matt Money from legal. Right now, these charitable organizations are defined in code in 2934-213. They're charitable units of a religious or civic group that are exempt from taxation under 26 USC 501 of the tax code, and they include those supported wholly or partially by private donations, and they are registered with the Secretary of State as we speak. They provide services that include providing food, housing, and shelter from adverse weather, including allowing persons to enter the premises for purposes of temporary shelter from severe storms. What this bill is attempting to accomplish is to allow them to enter into a contract or an agreement for consideration or without consideration with a state entity for the purposes of using an official state logo, not necessarily the flag or the state seal. It could be some other logo. It could be a developed logo specifically for these particular entities so that they could use it during the course of providing these various services. That's essentially what the bill does.
I think I have one that's called a cross, isn't it?
Yeah, no, that's all right. And trust me, I had some questions about this too when I spoke with legal, was working on this, but all I'm trying to do.
Hang on a minute. Hang on.
Okay.
Before you'll be activated, we need to go back in session.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, all I simply am trying to do is when we will continue to see this, and it's a very urgent matter, when there are severe weather events and you're out in the public and you're not close to home. This happened to me, actually. I was driving near Shelbyville, and Chairman Marsh, unfortunately, called him up on his cell phone, and he let me come over to his house, my family and I, and we took refuge in his house. And that's when that derecho, or whatever you call it, straight line wind came through that was pretty significant. It caused a lot of damage. So when people are out and they need a place to go and they're exposed, literally this can save hundreds and thousands of lives of Tennesseans. And I'm just trying to make it simple. This very simple bill, I'm just trying to make it identifiable so they know where to go.
I think I'm kind of like getting in the mode of Chairman Bricken now. I think it's a great idea, but I think some of these organizations need to come together and design this logo and approve it and then present it back where you've got something to work with.
Well, if I could, Mr. Chairman, there are a few organizations that have already worked on logos, but ultimately it would be up to those state agencies to make that decision, what they want to accept.
So, I mean, I hear you loud and clear, and I agree. But I want to see something that everybody's approved and can be recognized.
And I just say, the issue with that is if we were to go through and approve every single thing, our.
Well, it's like a Red Cross emblem. It's, I mean,
Well, that's, Mr. Chairman, that's why at the end of the day, the agency would have that, decision to make.
have
that.
you, how much have you worked with them to try to get an emblem?
Well, one of the, there's already a pretty well-known emblem out there.
Yeah.
So the problem is when people start creating their own things, it get confusing to the public. So this makes it so that there's consistency, to identify those logos.
How does it if you don't have the logo? I'm trying to put this together.
Well, that's the thing. If you have a patchwork of logos that are out there and there's not an official logo, then it's recognized by the state. People might not know that, what it's for, what's they're able to do. So that's all I'm trying to do.
Representative Chair Lady Littleton.
Thank you, Mr. Chairman. There has been times when I lived in the real rural areas, that people came to my house to the basement as well. But we have the Y, and in rural areas, you don't have places. So we have the Y in places like that. Or one time a storm came through and we all ran up to the CB store, and got in there because it was a structure. But when the storm's coming, you're not looking for an emblem. You're just looking for a safe place to go, especially in rural areas, in country areas.
Right.
Thank you, Mr. Chairman.
And I'm not saying you look for the emblem simply would help identify where those safe places to go, because the safe places legislation that we created help those community organizations that want to open up their doors to be, be protected against certain liability, so that it provides more safe places for Tennesseans to go.
Representative Chisholm.
Thank you, Chairman. So thank you for the bill. I think we all need a safe place. But my question is, seem like we still have a lot of questions. So would you be willing to roll this bill?
I mean, it's a pretty straightforward bill. I don't know.
It is and it isn't. You look at the whole committee up here, we're all kind of strung out, confused.
I'm at the will of the committee, so whatever the will of the committee is.
I think what we're going to do, if you would like, I think we're going to roll this 2 weeks and give you an opportunity to work with some of these members, see if you can get some clarity on this.
I'm happy to do that.
All right. Thank you. Without objection, we're rolling HB 1959 for 2 weeks. And we have 5 minutes. We have a motion second. Is this going to take longer than 5 minutes, Representative Slater?
I sure hope not.
The first two bills been an hour and a half, so.
They went quite a while. This is House Bill 1919. It is a mutual aid act. Thank you, committee and chairman. As members know, mutual aid is when one jurisdiction requests aid from an outside jurisdiction. This bill modifies the definition of mutual aid. Currently, an occurrence of mutual aid is when there is a threat of an event or an actual event and its aftermath, whether natural or man-made, that could lead to substantial, and that word substantial is key to this legislation, substantial bodily injury or property damage, and that little word also is very important to the legislation, and that could lead to the declaration of a state of emergency. So now we get to being very straightforward on the change to the definition of mutual aid. This bill would remove the word substantial and remove the requirement that it could lead to the declaration of a state of emergency. This change would ensure emergency personnel and departments are not inadvertently losing their liability coverage when responding to mutual aid calls. The reason for this bill is that sometimes first responders may respond outside their jurisdiction to an event that is not a major event. But if they do that, they may be outside of their insurance liability. And with that, I stand ready for questions.
Chair Lady Littleton.
Thank you, Mr. Chairman. I'll call for the previous question.
Call for you're trying to make this a quick bill?
It's a good bill, so
Okay.
I call for the question.
Without objection, seeing none, we're voting on HB 1919. Those in favor say aye. Opposed? You're moving on.
Thank you, Chairman. Thank you, committee.
And with that, actually, believe it or not, that completes the calendar for today. Without objection, we are adjourned.